Hello, my name is Muhammad Alam and I am a senior barrister and lawyer and also owner of Alam Law. As majority of you know that we are lawyer who have very exclusive and a special practice on personal injury law and also any dispute with insurance company. With respect to personal injury, today I'm going to talk about what if your child is hurt at a school or at a daycare and suffered some injuries? What are your rights? What you can do for those injuries that your child suffered? Or the second part of the injury claim could be that you suffered injuries while you are attending a recreational facility, so either a park, a playground area, a golf course, anywhere that you pay money and you go and use their facility, what their obligations are towards you. So let's talk about first part of our discussion today, injury to a child at a school. So if your child is hurt while your child is in a classroom or a school, or even if your child was at the playground of the school, children are playing, this one of the child is suffered because one, for example, let's say one kid hit another kid, and as a result, your child suffered injuries. Generally, we think about, one child has, being into the playground, people can, or child can get hurt. While that is true, but at the same time, when your child is hurt and you consult and retain a lawyer, because we, as a personal injury lawyer, when a client comes to us, we do some initial investigative work. And that's always free because it does not cost you any money. When you retain a lawyer like us, it's called contingency arrangement, which is no win, no fees. So you have nothing to lose to find out what happened to your child, to find out if your child was injured as a result of somebody else's negligence, not just only in the playground a child was hit by another child, but maybe a supervision. Maybe a school did not have a good system in place for a proper supervision, because they have obligation, once you hand over your child to a daycare or school, they have also some obligation to ensure that your child is safe. While they're playing, they're safe. Incident happened. There could be a time, a client comes to me and, the child got hurt. We did investigation. We couldn't find any negligence. So you may not have a case. But how would you know? You would only know when you retain a lawyer. And then we start doing our investigation to find out. We, send a letter to the school to find out about the incident and try to find out what happened. If the children were playing, how many children were there? What kind of play they were, they were carrying over in the ground? How big the ground was? How many teachers were supervising those children? Because there's a proper protocol available for the school that this many children will be in the ground. So how many supervision or supervised staff should be there? And if they were lacking into the supervision, then there is a negligence on the part of the school that they did not provide a safe environment to a child. As a result, one child got hurt. You or your child has a case against the injuries that your child suffered. So again, lesson is this: you have the right, but most importantly, when that happened, calm down. Do not start giving a statement to the school. I've seen school, many parents, like, they will present their child for a statement because these schools are covered by an insurance policies, and insurance company steps in and they want to take a statement from you, because a child is a child. He does not understand some technical question and why this question is being asked. If you have a lawyer standing beside you, and if I believe that it will be better that my client's child given a statement, I will be supervising that statement. I will make sure that insurance company does not ask a question that they are not allowed to ask questions. So that's number one. Number two, second part of our discussion today, about you being using a recreational facility, or a library, or park or some other facility. They also have the same responsibility. That's called Occupiers Liability. Under Occupiers Liability Act, the owner of the facility owe a duty of care to you, and if they fail in that duty, and as a result you suffered injuries. So take an example. Even if you are playing, you are taking a ride, and something happened. A buckle was not tightened up. You fell down from the ride. You were taking for example, let's say another example, which just recently we have been retained, that you were given a horse. You went to a recreational facility. You were given a horse to ride. And as a result, something happened, horse did something unexpectedly, and you fell off the horse. Sometimes you can think about, oh, you fell out because you did not have proper training to control how to control horse. But in law, the facility owner, they also owe a duty to you. So for example, they cannot give you a venture for which you are not trained. And if they have offered you without asking any question, they are also responsible for your injuries. Let's talk about, for example, horse riding. When we sued those facilities who were providing horse, and horse did something wrong, all of a sudden, and you fell, we can investigate. We can go into the detail about their protocol, when this horse was brought to this recreational facility, what was kind of a training, how many hours this horse should be on the ride or on the trail, whether or not the horse was given proper food, whatever their requirements are or their protocols are, because there could be possibility that they did not give food to the horse properly, or the horse was not trained for the trail so people can ride. And if we find those information, then you have a case against that facility. So this is one example. There could be many, many examples, through which we can prove that the facility owner are responsible for your injuries. Let's talk about, there are times when people will come to me or contact me hesitantly, and they will say, oh, by the way, but we went to this trampoline park, and there's a disclaimer which I have signed, which says that if you suffered any injuries, they will not be liable, and your signature is there. When you call them, and they will show you the disclaimer that you cannot sue them. Well, that is not true, because you may still have a claim, even if you have signed a disclaimer, because all we have to look into it whether or not they have discharged their obligation. If they were negligent, doesn't matter, you have signed the disclaimer, you still have a claim against them for your injuries and losses that you have suffered. If you have any question related to this issue that we have discussed today, or any other legal matter, feel free to speak to us. Call us at the number provided on the screen. Myself or one of our lawyers will be able to help you and guide you. And if you have any case where your child is hurt, or you were hurt, or your friend or family members were using a facility and they are hurt, they still have a claim, a potential claim against the facility. But again, you have to choose a right lawyer, a lawyer who has experience in that kind of area of law, who has ability and capacity to fight your case and get the justice that you deserve. Thank you for watching.